4 11/2012, 11:20 a.m. Adam Floyd, Pat Hanley. Floyd's number. Pat, Pat, Pat.
Yes, I'm here.
Okay, hold on.
11:20 a.m.
Pat Hanley. Pat Hanley.
Yes, sir.
Come in, Agent Orange.
Here's Sam Floyd.
Adam Floyd, Elliot Bernstein, and Pat Hanley.
Hey, Elliot. How you doing?
I'm doing good, and yourself?
Fine. Good morning. Good morning, sir. And who is the person? Pat Hanley.
Pat Hanley is one of the legally related cases to my RICO and antitrust in the federal courts by Sheriff Shinlin, the federal judge who related our cases as well to the whistleblower case of a New York Supreme Court attorney.
Say, Pat, you're an attorney? Negative. No, negative.
No, he works with one of the cases that's in that federal lawsuit.
I was on the call with you the first time we spoke. Okay. You may have forgotten. But anyway. No, yeah. So what can I do for you, Elliot?
I sent you a letter. I was following up on it.
Well, I mean, your letter was not well received, obviously.
What? I
Yeah,
really?
you seem to have a habit of accusing people of pretty serious offenses. You accuse me of all sorts of ethical violations. Very clear to me you don't have a very good understanding of ethics. I don't represent you as an attorney, so I don't have ethical obligations as to you.
Yes, that all was predicated on us not moving forward politely. And that was just to establish that there are issues here that are related to conflicts and other issues that I do understand very well. And you know, Adam, I just want to be upfront with you on that. Um, Obviously, understanding that somebody put a bomb in my car, that I am in a federal RICO, that a lot of people have been trying to position around us and do us harm, uh, mostly attorneys.
Okay.
Starting with Mr. Joa, you can understand my need to put that out there up front with people who are coming to deal with me. And whether you right now take the choice of not talking further, which I then have issues with obviously a lot of the other people involved in this, AT&T, etc., then I will take the steps that I've taken in the past with other companies that are involved in this, who are named as defendants in the lawsuits, in efforts to uh, recapture my stolen intellectual properties that are being used in a host of illegal ways by a host of people. And in this case that you called me on, it involves two defendants in my case. So it's kind of really crazy the position you put your foot into, which was shocking to me, by the way.
What
But
is it that you're talking about? Because I have no idea what you're talking about. What do I have to do with the fact that someone tried to blow you up?
Ray Joa does.
Me.
Ray Joa does.
And what does that have to do with me?
Okay, AT&T does.
How is AT&T involved? AT&T is opposed.
Well, I expressly explained to you that Mr. Armstrong and other people had signed NDAs regarding my technologies, all of them included, not just the imaging,
Okay.
not just the remote control stuff, but some pretty backbone stuff that operates their networks. And
True, I don't know. I haven't talked to him. Assuming I know it's true, what does that have to do with AT&T and someone trying to blow you up?
okay,
How is that tied in?
because both are defendants in a federal RICO. And in a RICO, I'm sure you understand that all the predicate acts are charged to all the participants, whether they directly put the bomb in the car or not.
So how is AT&T tied into a criminal enterprise with Joe?
Oh, well, because it goes back to Brian Utley and Chris Wheeler, the law firm Proskauer Rose. And,
Do with AT&T though?
well, AT&T, why do you think they signed those agreements with us? The non-disclosure agreements?
Tied.
Because what?
How is that tied to this criminal enterprise?
Okay, because Ray Joa worked with the group of criminals, those same group of people we just spoke of.
Yeah, who are not AT&T individuals who
Yes,
with
no,
AT&T.
no, they are AT&T individuals. I gave you their names. Armstrong, the CEO, in fact. So I can't get much higher than that. He was directly involved in these things.
You're saying that the CEO of AT&T is tied to Joe?
Yes, and through the RICO, they are tied together, whether they are tied directly or indirectly as part of the independent parts of the criminal RICO organization. It's explained to me by, some very uh, good attorneys in RICO and other people that have interest in what's going on. So yes, in a RICO, all of the conspirators, whether they know each other, work directly or indirectly, if they're working for the criminal organization, are tied together. So that's why I'm saying they're both defendants in a RICO.
You have to tie AT&T to the criminal enterprise, and the only thing I've heard you say is they signed an NDA, which has nothing.
Well, there's a lot more to the NDA than that. Meaning, the lawyer from Proskauer, being best friends with the guys from AT&T, had a lot more discussions of royalties and other things and deals, but they were also involved in moving the technology out the back door, which Joe and others were involved in. And those things, those issues, as I've said to you, or you can find most of that up at my website.
I've gone to your website, so tell me what evidence you have that the Proskauer attorneys are best friends with the AT&T CEO.
Lots.
Give me an example then, should be pretty easy.
I have records of their contacts with them. Oh, excuse me?
Tell me.
I just told you. I have records of their contacts.
Now, you seem to make these wild allegations.
Okay, whether you think they're wild allegations or not, the bottom line is they're in a federal RICO. So it's not wild. Okay.
Federal RICO against you.
Yeah, and then you could have.
Make it true.
Then could you have a federal judge relate that to a whistleblower inside exposing all the attorney corruptions? I don't think so. But look, if you're arguing on behalf of AT&T,
I'm not arguing on behalf of AT&T. Your letter was directed to me.
well, your client's AT&T.
Yes,
So
and as you should know, given as much as you seem to know about the law, as I represent a client on a case does not mean I represent all of AT&T for all matters. I represent them on a case, a patent case, not your RICO case, against Joa. I represent them on other patent cases. Your letter that you sent is directed to me. You've accused me personally of all these ethical violations, which you have absolutely no basis for those accusations.
Which ones? Let's be specific.
You said in your letter that I violated ethical rules because I have a duty to report Joa.
Well, you absolutely do. If you, according to your own quotes, have believed that he's involved in nefarious activity, criminal activity, of taking other people's inventions, you have, and the obligation to now notify the court of what I've informed you of Joa being involved in a RICO, etc., and you suppress that, you will have violated your ethical canons.
Well, I don't think you have a very good understanding of ethical canons, number one.
Pat, do I have a good understanding of ethical and misprision of a felony as well?
I don't believe your allegations.
Okay, but that's great, but you still have an obligation to report them. And actually, by the way, they're your obligation. You put it in writing, sir, that you have information that Ray Joa might have lifted other people's technologies. And so your words need to be reported, as well as the information that's been told to you.
to
And you
understand.
need to report to your client.
It's only unethical for me to go and make these wild allegations without.
Okay, you know, wild allegations, I don't think we're dealing with wild. We're dealing with, let's just say, factual evidence.
Against judges,
Yes,
tons of attorneys in this
yes,
huge worldwide international conspiracy,
yes,
billions of
yes,
dollars. That's
yes.
pretty damn wild, Elliot.
Is it? Well, it's in a federal court. It's tied to a whistleblower who's,
That's in federal court. I can file anything in federal court.
I know, but can you have the judge related to a whistleblower and 9 other cases of inside corruption?
They're all related.
They what?
That they're related.
They what?
Found is that they're related.
Excuse me?
Any merit, one of your cases was dismissed, and you were sanctioned.
Who was?
So, there was that.
I was sanctioned? Well, nonetheless, that on your obligation to report things as an attorney, we'll leave that up to the bar association in your state, and we'll leave it up to the people involved in the ongoing criminal investigations that are ongoing. As you might note, I will be sending copies of this to the people who have been investigating the I Do It Affairs now for a number of years, and you'll be added forward to all of those things. Now, have you notified AT&T of the letter?
Well, so, just so you know, and you better do your homework on this.
Okay.
Start dragging my name and stuff,
Yeah.
yourself, serious trouble.
Okay. Oh, you can tell I'm afraid of that with the number of judges I'm suing, other state officials, and the other things. You really, your threat is just riveting me. My door is open, by the way.
Everyone thinks you're in that job, Elliot.
Who does? Who's everyone? Tell me who everyone is.
Yes.
Who?
The reason that
Who thinks I'm a nut job, sir? A lot of people think I'm an inventor who you're pilfering in my stolen technologies. And that's evidenced by the signatures of your CEO at AT&T, your client's signature as CEO. And so, you know, your little threats and your little things sound like a little fairy attorney. And I've dealt with you before, and I will literally put you into the SEC complaint today. I wasn't playing around when I sent you that letter. I don't know what the hell you called me for, involving me to talk to you about Ray Joe and AT&T. Two defendants in my RICO, two people centrally involved, and actually possibly centrally involved in the car bombing, as I don't know that yet. But nonetheless, you know, you're threatening me. I'm not threatening you. I'm factually alerting you that you are now a part of I View It. Welcome to I View It, in fact. And you should notify your client of the liabilities that they have in these matters and of what's going on with Raymond Joa. And you should do the right thing and report Ray Joa for criminal behavior as an attorney. That would be your best protection that I could see for a smart guy like you who doesn't want to get caught up in the middle of this, is to simply notify the courts that you've been contacted by me and that here is the letter, and it exposes a lot of corruption about Ray Joa, and obviously you've looked at the documents which Mr. Joa pilfered my patents. And so a nut job and things like that, sir, you got to be a nut job to have called me with after knowing that you've researched me. There's enough literature that, you know, didn't you know that before you got in bed with me?
Explain this to me. So,
I told you this is a marriage. We're not getting divorced quite as easy as you think.
how does Raymond Joa file applications on your supposed invention 2 years before he met you?
Look, there's so many patents he filed. There's 90 of them. I haven't looked at your shit really, because I really don't care. But the bottom line is, the bottom line is, Ray Joe is under investigation at the United States Patent Office, Office of Enrollment and Discipline, and you're going to be in a minute too. And I am telling you, the best move legally, and you know, I actually did read all this stuff, is to notify the people and get yourself protected. You know, you have obligations as an attorney not to attack me in the information I've given you and threaten me, but to in fact notify the proper authorities. You're in a federal lawsuit right now with Mr. Joa. I would notify the courts of what you found. You might choose to notify them that I'm a lunatic for all I care, but whatever you do, notify them.
I'm not
Because
under an obligation to notify him.
oh, if you don't feel
Now
you
you
have
have a
one,
bunch of
if
allegations that you can't back up.
if you do, if great, if that's how you feel and you want to risk it all on that, great. I was just showing you a way to hedge your protection, so to speak.
You're showing me what you're trying to do is you're trying to get me to back up for allegations, which you have no
I'm not
evidence
trying to
of.
make you made allegations in your letter, sir. You made allegations that you had information. Don't try to double talk me. I know what's just going on. So, you know, you made this claim. You said you have information. Now you have more information. Now you have legal obligation. And you have obligations to your clients and fiduciary probably with them in every way known to man. And you're not going to get out of this by simply calling me a lunatic.
I think you are a lunatic.
Okay, you know what? That's a great. Are you psychologically trained?
No, but you should be medicated heavily.
Okay, great. I'm glad that you think all of these great things. But the bottom line is, sir, I've changed the world and you've disgraced the world. So now the game is up to you. Do you want to put yourself in the middle of the RICO? I'm fine filing the SEC complaint today. You can see I filed against Intel. Bruce Sewell left his job moments later. I filed against SGI. The attorney over there filed a bankruptcy 3 days later and split. You might start wanting to check out some of your predecessors, and you know, and I've heard the threats before and the claims before. So you won't be the first, and you won't be the last, and you certainly aren't the biggest, by the way. So, with all that said, I will take it that you don't want to negotiate further on behalf of your client, AT&T, to get them out of the RICO.
Negotiate what?
Just what negotiate a settlement on the royalties that your client AT&T owes me, not Ray Joa, on the technologies I invented. And if you want to get into disputing whose they are and what they are and blah 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 blah, then I'll see you in the RICO with your client AT&T.
A
And
royalty on what?
uh, you know, seriously, did you read the letter?
You don't have a patent.
Okay, it doesn't matter. You can do it on patent pending, or mine are suspended, mind you.
Have a
Mine are
You have
suspended,
no
mind
cause of
you.
action.
Here, let me just tell you something.
Royalty.
My patents, you're right. My patents are suspended, and when they get unsuspended, it's going to be your mistake that you didn't notify your client AT&T that they had an out. Because at the out point of this game, when those patents become unsuspended, do you know the reason they're suspended? They're suspended pending federal investigations by the USPTO jointly with the FBI and other international agencies to determine the extent of fraud committed upon the United States by Joa et al. Okay? Now they're still suspended in that state. Now, the way they're going to get unsuspended is through the RICO. And at the end of the RICO day, and that day will come, and there's a long history you've just tied yourself into. So get ready. um, you know, put the house in the wife's name and everything. And what you're going to find is that at the end of the day, had AT&T stayed in because of your armchair psychology view of me, um, well then they're going to be part of the group that's arrested, prosecuted, and the licensing could be the end of their companies. So you might think that's a joke.
I think it is a
You,
joke.
you might think it's far fetched, that it probably won't happen. I'd get an actuary to start assessing your risk and your clients. By law, you should have already been notifying authorities, and AT&T now through their counsel should be notifying authorities. And by the way, as you slip out of doing that, charges will be filed against you and your client, whoever's handling the legal. And I'm going to call over there since this call didn't go very well. and I'll talk to their general counsel, so you might want to tip them off that I'm calling. And at the end of that row, I'm just going to file the SEC complaints and add you guys as defendants in the RICO, and you can do whatever you're going to do uh, to me in whatever response you were planning on telling me about in your coveted threat. And, we'll move forward from that. Now, I was giving you a chance, by the way, because of your braveness to contact me and stick your toe into such mud after you had already read my website, was an opportunity to be the hero of the day to AT&T and T and say, hey, guys, I've reviewed Elliott's suspended patents. And to get them unsuspended, there's going to be a RICO action one day. And do you want to be in the middle of that, or do you want to be Elliott's friend? So take a good look at the patents, see if you're infringing on them. And if you are, pay him the royalty that's owed to every inventor who invents things. If you want to fight it, it's going to get RICO-ish here, and there's car bombs, and there's all kinds of other real bad things that occurred here that have, some of them have been held off, but it's all erupting, and there's whistleblowers, and it's federal, and there's lots of things going on here. And at the end of the day, he's asking for a license. He isn't greedy. He isn't trying to knock you out. He's saying, pay me what you owe me for the last 10 years since the day you signed an agreement with me, and walk yourself out of the RICO and car bombings and tape phone calls between Armstrong and Proskauer and videos of them planning things and all kinds of wonderful conspiratorial things that I'll let you in on as you go to prison. Now, that's your other option,
Hey,
is
Elliot.
say no, and that's where we go.
Elliot,
Yes, sir.
I'm going to record this call, okay?
Absolutely.
Thank
You're welcome. Did you record the part where you threatened me?
you.
Oh, well, let's put that back on the record then.
Yeah, so the way it went was you threatened me by saying you were going to sue me, bring me into RICO action.
Okay, but that's not a threat against me.
And
Against
my
you.
response
A threat with a lawsuit is I wasn't threatening you, by the way. I, in fact, told you factually that I am including you in the lawsuit. Take this as official notice. Actually, after 5 days, the letter told you to notify your insurance carrier that you have liability. So I would notice them right away. Now you're officially noticed, and your receipt, constructive receipt of the letter and acknowledgement with that, and I on the phone here today, also should be put in there that you have receipt of a letter that notified you that if you didn't sign the conflict of interest, which you didn't, that you have liabilities, and you have so many liabilities now that we've already discussed that please, you know, tell me what you want to do. Do you want to negotiate, or do you want to be, added to the complaints?
So what you're telling me is either I can negotiate a settlement on behalf of AT&T for your patents which have an issue, and if I don't, you're going to add me to a criminal action, threatening to try to put me in prison.
No, that's not what I said. I can't threaten you with a criminal action. I'm not a prosecutor or one of those kind of guys. What I'm telling you is that you have obligations as an attorney. You've admitted that you have knowledge that Raymond Joa might have pilfered people's patents and other nefarious things. You contacted me regarding patents of Raymond Joas that might be infringing upon my patents. I notified you that Ray Joa is under federal investigations, and you should notify the judge in a federal court that you have obligation to notify that Raymond Joa is under a multiplicity of investigations, whether you want to call them fantasy or factual or unfactual or based, that's great. But just notify, because that, by you failing to do those things, you will be violating your attorney conduct codes, and I will file charges on you. I will add you as a defendant in the RICO for contacting me on behalf of two other defendants in the RICO, AT&T and Raymond Joa, and I will move forward with that regard. I offered, on the other hand, if you were contacting me and doing the right things, notifying the court of Raymond Joe as, being investigated by the OED of the patent office, don't you think that's kind of pertinent to your case there? Yes or no? No, Ray Joe is being investigated by the United States Patent Office, and Mr. Bernstein's patents are suspended pending that ongoing investigation with federal authorities. Is not important to the federal lawsuit that you are in with your client, AT&T, Zambu, and Ray Joa. You're telling me the judge shouldn't know that? And that you have other information of possible criminal activity by Raymond Joa with his other clients? You don't think you as an attorney have an obligation to report all of that to the proper authorities as you've taken oath to?
I don't know what you think you understand about the rules of ethics, but
Enough to have busted enough guys in it, including the former president of the New York State Bar and two senior ranking officials in the Florida Bar, and caused quite an uproar. But yes, I think I might be an expert on it, but go ahead.
you never want to see your suit have been dismissed.
I really, you know what? My suits being dismissed doesn't really matter when the lawyers and the people involved were corrupt. Now, that's coming out, and I don't think Sheriff Shinlin's case is quite over yet. But if you do, advise your clients of that. But you asked me, I didn't threaten anything. I just told you what's happening. So as you fail to notify, as you fail to notify,
I should put my
as you fail to notify,
let me finish.
if you fail to notify a federal court, I will be notifying federal authorities that you have information regarding felonious activity of a one Raymond Joa, and that you are failing to disclose that to federal courts, that there's possibly a fraud on the court, and that you will be involved in obstruction and other things that relate directly to my RICO.
Okay, so now can you listen to what I have to say,
Sure.
please?
Yep.
First of all, you lost every case that you brought.
Okay, look, you can attack my legal cases till the cows come home. I really don't care. If you're not worried, don't worry. But I'd be worried when a federal judge relates it to a whistleblower, 9 other cases, and there's a whole lot of eyes on it and it's all peeling apart. I wouldn't want to be you sticking my foot in the middle of this and not covering myself by doing what's required under my your attorney conduct codes and law. I mean, look, if it's all crazy, just notify everybody. Notify the federal court. There's a crazy guy, L.A. Bernstein, with crazy suspended patents and all these federal investigations and international patent office investigations and all kinds of shit that could go wrong. Again, I don't want to really tell you, but if and I don't know if you're a risk analyst at all, but you certainly sound like you're making risk analysis for people here, including yourself, and you're failing to look at what you're obligated to do by the federal court you're in. I mean, you contacted me. This is information you must disclose. And if you don't think you have to, we'll see.
You don't have to, Elliot.
Uh,
If you let me talk, I could possibly shed some light on it for you, but you don't let me talk. I've been doing this for the last 25 minutes.
well, every time you talk, it's like insulting. But go ahead.
I try to talk, you interrupt me.
Okay.
Number one, I don't have to report just because I have a suspicion and I'm investigating Joa. Unless I have evidence, not only do I have no obligation, it'd be irresponsible for me to report it. Number two, the evidence that you provided me was after Joa had filed. You admitted this. He filed 2 years before he met you.
I didn't admit anything. I said lots of documents have been tampered with. Ray Joe has been tampering with documents. That's what's under investigation at the patent office, and that's what you should be reporting in the federal court as well. And that's what he's under investigation for. So I really don't believe any of the dates on Ray Joa stuff. If I showed you, he dated stuff of mine that he filed at the patent office with dates of 1900 and 2020 on them. Now, those are official patent documents. And people could swear that Ray Joa was there in 1900 faxing his invention of my invention. Ray Joa is a con artist. His documents are frauds. You got to be kidding me. I've given you massive evidence that this guy is under investigation. I've given you evidence that there's investigations of him. you can call the patent office. You are more than capable of, going in and getting your footing now. You're in deep. So, we're married as far as I'm concerned for a while. And so I'm more than happy to have all these conversations with you. But I am telling you, you have obligation. And yet, definitely to the court, that there could be a fraud going on the court where Raymond Joe has been found in other, including ethics complaints, messing around, and he was ordered for investigation by the first department. You know where that investigation went? Nowhere, but it's under investigation because they all had to break the rules to do it. So, we're slowly getting through the amount of lawyer crimes going on here, but you definitely, in my view, got to read your book of ethics again and figure out if, some of this borders on fraud on the court. Meaning, going through with this hocus pocus with acting like Ray Joa's, patent. We should be looking at what it says and what day he filed it when the guy's been frauding documents to the patent office. And he's under investigation, and it's led to my suspensions.
He's under investigation because you put him under investigation.
No, I didn't. Hearing Motes, the director formerly of the USPTO OED, put him under suspension by having me draft a letter with his aide. And remember, he put together a team of 9 guys at the patent office who got my patents, all the answers answered. They threw off all the attorneys, a whole lot of things going on for a guy who's, just spewing crap, right? Hallucinogenic guy like me, like you were calling me. Um, Hearing Motes advised me to write a letter to the commissioner of patents, who is actually the person who approved the suspension. Um, and that letter, he had me title Fraud on the United States Patent Office, not fraud on Elliot Bernstein. And I said, fraud on the United States, what are you talking about? I said, yeah, when these guys sign these bogus applications, well, my God, they frauded the United States, not just you and your investors. So I wrote that letter to the commissioner. It's up online. I'm sure you read it. And that's what got him approved, pending, in the department's own words, investigations of these guys. And so, these are real things you just stepped into. You might want to discount them and say that I'm crazy and we, the people, think you're crazy. I don't know who you and we are, but, like I asked you to put that down, who we think you're crazy. Who is it, by the way? You never told me.
That's because you never let me talk.
I did let you talk.
So you did.
Okay.
10 seconds, and then you went on another fucking rant for the last 10
Well, because you're saying crazy things.
No, I'm not.
You are.
I'm not the one with this grand conspiracy theory.
Oh, please. It's not a conspiracy theory. It's a legal conspiracy. And at the end of it, if you're convicted, it's 10 years. And right now you're hanging around with one of the biggest conspirators, Mr. Joa and Mr. AT&T.
Then I'm on the opposite side of the case.
No, well, you're with the other defendant, AT&T, in my RICO.
Oh, yeah, they signed an NDA. Woo.
No, it's not quite like what you think. Like I told you, there's a lot of evidence. Mr. Armstrong should know what I'm talking about.
Saying that, I haven't seen any, though.
Yeah, call Mr. Armstrong and ask him if he knows Mr. Utley and Mr. Wheeler.
I have better things to do with my time. This is your case. This isn't my case.
It's your case. You called me. You called me.
Yeah, I called you about my case.
Oh, well, you know what? It's a lot bigger case. It involves my case, and your case, and the case against your client AT&T, and the case against Mr. Joa. And so, yes, now you're central, and the party has started, and I believe you have obligations legally and ethically, now that you have this information, whether you want to believe it's true or not, to notify the courts and others of your knowledge. If you suppress this, this could also be affecting AT&T shareholders and could be construed as fraud upon them. Because AT&T's got a liability that as long as those patents are suspended and they signed an NDA, no matter when it was, They got liability just with that document. Now, I know you're a lawyer, and I had a long insurance background with a lot of lawyer friends. And, you know, you got liabilities here. I'm just saying, do the right thing. You know, notify the proper authorities of what's going on, why you contacted me, what you found out, put that into the record on Joa. And if you want to settle out AT&T and make yourself a gazillion dollars, uh, God bless you. If you don't, and AT&T isn't reporting this properly, and I'll be checking with their attorney in a moment to make sure he is, um, you know, then we're going to file a series of complaints. We, you know, have done it before. I thought this was a good door opener that you were ballsy enough to call me regarding anything, to be quite honest, as a lawyer. Um, and so again, I'm gonna, you know, you've got a brief window here as we start typing an SEC complaint to contact your client and notify them that there is an offer on an old NDA. Now, remember, by the way, the BlackBerry suit was won on an NDA. It wasn't one on the patents. Of course, they were still patent pending. And I know you, being a patent lawyer, knows that there are advanced royalty agreements, favored nation, all those legal jiggity jiggity terms for patenting in advance of a patent product. Now, I wasn't born yesterday, and I think that that's the best thing for you to do. Meaning, if I were you, I'd say that's an opportunity.
Do you even know what an NDA is?
You know, I know so much more about Mr. Armstrong's involvement in this than I wish to relate to you at this moment, but I have to federal and other authorities. And excuse me.
Furthermore, the RIM case that you referenced, I'm intimately familiar with it.
Oh, good.
It was a patent case.
It wasn't a patent case. The patents weren't approved. It was one on a non-disclosure agreement. Check your facts. It's
RIM,
okay. Check.
District of Virginia, and it was a patent case.
Okay, it's not a patent case. It was one on an NDA. And that was all. And the judge gave explicit orders that, you know, if you want to hold it up in court for till he gets his patents, we're going to put a little injunction on the technology that will freeze up BlackBerry. I intimately know the case, but anyways, um,
Affiliate, that's not even remotely about that case. I've read that case numerous times.
have you?
Yeah, and I know
Okay.
the lawyers that worked on the case.
Okay. Well, you know, then we both know different things from different people who are intimately involved. Okay, but on to more important things. You've never heard of a advanced royalty agreement? You've never heard of licensing a patent pending concept? Never?
Yeah, you
Good.
can.
Good. Well, you know what? If you want to hold out and share it through the eventual RICO that's coming, and it's in play, you're more than welcome to advise your client of that strategy.
Well,
I didn't contact your client. I am taking them on that strategy. Meaning I didn't call AT&T to offer them anything. I didn't call you. So, you know, that's what I'm offering you. I think it's an excellent move for AT&T. Um, and I think whether you want to believe it or not, that NDA ties them tighter to the technologies and the fact that they're best friends with Proskauer's Chris Wheeler and Brian Utley, formerly of IBM. I think few phone calls that you say are not worth your time would be well worth your time and well worth their time to sign a licensing agreement that then removes them from a civil RICO. I can't remove them from the element of the criminal RICO because I'm not one of those prosecutor type guys. So I only filed on civil. The judge booked it as criminal all on her own. So you know, I'm I'm willing to walk them out of the civil in a settlement based on payment of the royalties that are typical and customary to inventors. That's the end of my conversation with you. I I am happy to notify you if you want AT&T's response after I contact them.
all right, well, this hasn't been a conversation because all you've done is talk. You haven't listened to anything I had to say.
Did you send AT&T the letter?
Oh, you gonna let me talk for a minute?
Yeah.
I want to make sure I understand your.
No, don't paraphrase anything I said. Seriously, you're on tape, and so I hate people paraphrasing on tape.
So if,
Oh,
and I'm not saying we're agreeable to doing this,
okay.
AT&T is willing to pay you a royalty on your patents,
Pat,
which have not issued.
suspended.
If they're willing to pay you a royalty, then what you're telling me is there will be no further filings of RICO, complaints to the bar, no other action on your part
Against who?
against AT&T
Period.
or against my firm.
Oh, um, yeah. Meaning if, well, because, well, let me ask you this question. Ethically, do you feel you should report Joe to anybody at this point? I don't know what, put it off the record if you'd like. But my question is, you don't even have to answer it. I'm just going to ask it, and then you can continue that. If you're saying that I won't do that against you or your firm, if AT&T, if we end up with a mutually good agreement here for everybody, my only question is to you: will you be ethically still bound to do it?
No,
You won't.
I don't have evidence at this point that Joa did something wrong.
Okay.
I'm not giving up. I'm investigating.
Okay, no, and I
Nothing.
understand what you're saying. I understand your answer. Um, yeah, I would feel comfortable saying that to some degree, that you doing the right thing in that response and getting a defendant in the RICO to to uh, pay a settlement and royalty for all of that. Yeah, that I wouldn't file against them or the people who made that happen. Absolutely. I would have no need to file. I would first of all say that you were a very smart lawyer, which I would give you a lot of credit, and I think AT&T would. Meaning, from a risk analysis, it doesn't make any sense for AT&T to want to continue getting dragged into a RICO that they do have central people attached to in central ways, and that could just become disastrous. Versus looking at the patents and saying, did Elliott Bernstein invent these technologies? Okay, nobody else has come along and said they did. That's the first thing. And so nobody was there. And then there's a lot of investors. And then there's all these people. The government's an investor. And all these people are investors. And then it looks like some attorneys try to rip them off. And you've got one of them in your pocket, by the way. Uh, you know, I can't imagine AT&T saying he's not extorting us. He's asking for what most people who invent and and then maybe they might look around and say, well, we paid MPEG all these royalties, and I would say go collect your money back from them, and that would be about it. And from there they've had a great use of my technology, which has expanded all of their markets. And believe me, if it gets to a cost battle, it's going to cost so much more to settle out that it'll be catastrophic, and the shareholders will be outraged that they didn't take this opportunity to make a good settlement on the civil side. Remember, I can't do anything about the criminal side, but I would not file further against them if they did that.
Or against my firm.
Yes.
So,
I'd hire your firm, by the way. You'd be my next best law. You'd be like one of my best law friends. And I have a lot of those. I know it doesn't seem that any lawyers would ever consider the ilks of me, but I really do, and they're people I greatly respect. So you would become like one of my heroes, actually.
and so if we don't agree to this, negotiate with you, and I need to know this, so I'm going to go and talk to people. So you're going to file not only against AT&T, you're going to file against my firm.
No, I haven't filed, and I'm not sure exactly what your question is, because You said settle this thing with AT&T, so that's different than negotiating. Um, so so really, if you settled the thing with AT&T, then the actions that we would have taken based on your failure to do that, which would have caused felony possible crimes, yeah, correct. Then I wouldn't file on. That's right. Any other instance, I am going to file on you because I'm obligated to, and so are you, by the way. So we're both going to have obligations if you fail to move forward. Those obligations occur because of the failure.
Why do you have obligations? You're not a lawyer.
I'm a United States citizen.
So,
Well, I have a right to protect my country from criminals like Ray Joa and other people who fail to notify courts timely of criminal events and other things and notify shareholders of their clients who are defendants in RICO. So, that would become, violations of FASB possibly. You're talking all kinds of serious, complicated issues. I've run this through with a lot of people before. I called guys like Bruce Sewell of Intel, uh, the lead attorney for SGI, um, Lockheed. You could go, yeah, I'm sure you've gone through those things. I gave you some links to some of them. I've had these discussions. So, what's going to happen is that you're going to fail to do the right thing, which would be to attempt to negotiate. Now, if the attempt to negotiate failed, not because of you, but because of your client AT&T, then the only thing you would have left is some ethical things that I think you would have to report. So, you know what I mean?
or is the Joe you're talking about?
Yeah. And I don't think those obligations will go away.
And you think I have to report that even though I
To the
don't
federal court, absolutely. To the federal court, you absolutely have to bring this information to them. Yeah, I mean, because if you go and litigate that case and you play like it's all real and Ray Joe is not under investigation for fraudulently manipulating dates on patent documents, I mean, can you imagine what you're saying right here? Can you imagine trying to literally, when this does get due process and all this nonsense does unfold, do you really think your excuse here will have been right? I didn't notify them because I didn't think I had to.
I know I don't have to. I don't have any evidence. You haven't shown me any.
I've given you perfect evidence that the U.S. Patent Office is investigating Mr. Raymond Joa for attempted fraud on the United States Patent Office and that they're jointly investigating it with the FBI. So I've given you the best information I can give you regarding that.
Well, he's innocent until proven guilty.
Well, I totally agree. But if you go run this game through with the federal court on those patents, and you continue on that court knowing this, that this is all about Raymond Joab pulling fraud and under investigation, and you fail to notify people like your client and other people, you're going to have some issues.
I don't know that he committed fraud.
What, it doesn't say you have to have proof in the ethics books. Okay? It says if you have information or knowledge that another attorney has committed any act, read it. I'm telling you, go back, do that ethics class again. They might have left it out of your college. They've been leaving it out lately. Greed is good kind of mentality. But nonetheless, you know what I'm saying here. You have information of another attorney possibly committing acts. It doesn't say you have to have absolute proof after your investigation. And if you are going to hold on to that, you're going to lose. I mean, that's going to put you in that precarious position of being guilty of ethical and possibly criminal violations. Based on my novice, stupid, non understanding of the law as a non lawyer. And like, by the way, Raymond Joa, 10 years ago, I'm sure he thought I would go away too. You can think that, but this isn't going away. That contact of yours to me represents a lot. And on my end, it represents a real whole lot. If you, well, think about that in the sense of you contacted me on behalf of a defendant, AT&T in a RICO. They need counsel. You know, if you're contacting me on a separate blah, but none of that was in disclosed. And so I've got lots of issues with who you are, how you came about me, how you contacted me after seeing my website, you know, after reviewing all this. So, you know, I'm hoping for the best outcome here. I really am. I, I, you know, I don't mind filing complaints, obviously, against people who deserve complaints. And I don't care what their name or title is, as I'm sure you're aware, as you've stated. And so, you know, I really am hoping you do the right thing as a lawyer, because there are a lot of good lawyers out there. They're just incapable right now of doing the right thing because of some of the corruptions up at the top. And we've been dealing with some of those, like Tom Cahill in New York and others who are being knocked out in this investigation that's ongoing with our stuff. You might want to look all that up. And so, you know, if you do the right thing, yeah, you probably evaded all of the reasons why I will ever need to file upon you up to that instant in time.
Well, I guess I think the difference we're having here is what the right thing is. I mean, the right thing in your mind is.
Hey, no, that's not the difference. The difference is what the ethics book says. You better read it carefully, because if you have information about, and we're talking in a federal court, right?
You're talking about what?
You're in a federal court, right?
Yes, I'm in the front.
Okay. And you have information that another attorney may have committed infractions of law and ethics, correct?
No, I don't have it. That's what I'm
I
telling you.
didn't give you any information. Like he's under investigation. No, come on. Stop trying to play this game with me. You're not going to bait me onto your taped phone call to say something. Okay? I'm much smarter than you. I
Fine.
changed the world already. What have you done for the world? Let me start back with that question, because you really, the games, I hate games. And, you know, you're not the first guy to pull a fast one on me, get it? And they didn't get too far away. And they haven't got away with the crime. Okay, and you're not going to be the salesman that comes in and pulls one on me, and well, so I don't get these questions anymore. You know what I mean?
No, I don't know what you.
You don't, do you?
No,
Okay.
because you're not making sense right now.
Well, Pat's on, and Pat and I, you know, we know lots about law firms and lawyers. And the first question we ask is, why would you call after reviewing my website? Why would you not have run all thorough, you know, conflict checks with your client AT&T and discovered that I view it and Elliot Bernstein are in a lawsuit against your client? And I'm just not gonna, you know what, you need to read the ethics book again. If you think you're safe right here, then I'm happy. If you wanted to settle with AT&T and T and Elliot Bernstein, that might, by doing all of those things, and that might include reporting Joe at this point, um, you know, get you out of complaints. By the way, the complaints already have started, because right now you've been noticed that I am going to sue you, and I am putting you into all of these complaints. And I noticed you in writing, and so the first thing you got to do is notify your insurance company, correct? Yes?
That's not really your concern.
Is that correct?
That's really not your concern. What
Well,
is
it'll
it?
be an ethical violation and a whole lot more, because that becomes insurance fraud, as you know. And I'm an insurance expert, just happen to have a lot of friends in that business too, like the law business.
Or you're a legal expert and you're an ethics expert.
No, no, I actually have great friends in law. So if you looked up my history, you'll see that many of my friends are some of the biggest law firms in the world. I just happen to run into a few bad ones that we're chasing after who tried to run off with my patents. And we'll get every one of them. And remember, in a RICO conspiracy, the beauty of it is I can keep adding defendants to it as I amend the complaints, to further expand those involved in the conspiracy, those who came after the conspiracy to try to railroad me, to try to harm me, who threatened me on phone calls, you know, all kinds of things. And so I've noticed you. that you are going to be a defendant in that if you do not take the right acts. So I never threatened you. I said, if you do not act according to ethics and law rules, I will be fired. You may already have blown that by not signing the conflict letter, which is my opinion. But, again, it's non-legal. So, anyways, I have a lot of friends in the insurance industry, ranging from the CEOs of quite a few of the bigger carriers to law firms that, had a bunch of stupid lawyers at it, obviously. And so, I just tell me, they all would be reporting this to their liability carrier first because they have obligations when they're notified of liability to report it. Now, those obligations are legal, by the way, and you understand that, right, Adam?
I understand my legal obligations, Elliot.
To your insurance carrier. When you are notified that you are being added into criminal complaints, future, not threatened, but actually coming, all of this is now a real liability. And that's why I'm saying read the conflict. Well, you know what? Just send them the conflict letter. Tell them, here's the conflict letter, and it does tell me this. And you should tell your partners that too. And then we should get on to, you know, if there's a way out for everyone that does all the right things for everything. I mean, and that might include you reporting the information you have about Joa. And like I said, you know the game. You don't need to have factual proof of Joa's misconduct. I've given you more than enough information to satisfy the requirement that you must tell the federal court, at minimum, if not other federal agencies, and about what you've learned about your client.
Elliot, the information you gave me supported his story. I told you that in my email.
Yeah, okay, however you want to skin the cat. Like I said, you out lawyer yourself here, buddy. And that's fine with me. If you've got the answers and you feel comfortable, then you're set. But I wouldn't. I mean, really, no, I would notify my insurance carrier by, my legal obligations to the carriers. I would notify my clients of all of this, and I'm going to hope you have. When I call over to AT&T, I'm sure I'm going to get an equally receptive audience over there. And, that's where this is going. So, you know, it is probably, since I really don't think I'm going to settle much with them today, and I didn't before, going to end up in, complaints, SEC complaints. Um, Make sure that AT&T has now been noticed by their counsel of all of this. Make sure they notice their shareholders of all of this. Make sure somewhere on that balance sheet there's a contingent liability at minimum. Contingents if you know that you're infringing. And by the way, in a FASB, for your client's sake, by the way, just knowing that you might be infringing on someone's idea, not even patented, you literally should be marking it as a contingent liability. Here where you have the CEO directly signing an NDA, and by the way, the CEO of AT&T sign many NDAs, or does he usually have his legal department do it? But anyways, nonetheless, that's how good of friends they were. I think for everybody on your side, settlement is the best way out. You are now married to this as long as it goes. And these patent things go on forever. These federal court cases involving whistleblowers exposing internal corruption, they go on. You know how long they go on? Your children will worry about their assets, and if mommy owns them. You know what I mean? So I would start reporting everything to the proper authorities like you're required by law to do, and ethics, and be the man, call your client, get back to me, tell me if there's a deal on the table. If not, I'll call over to AT&T's general counsel.
Elliot, I believe that Adam Floyd asked for a copy of the NDA that Mr. Armstrong signed.
I think you have to call the Proskauer attorneys.
I've asked you for that before, and
Yeah, I know. You know, I'm very reluctant, but it's call Proskauer, call Chris Wheeler over there. He's the guy who brought in Ray Joa, by the way. He also brought in Mr. Armstrong. He directly brought those into the board members and investors of iView, including Huizenga and other numerous other investors, but including the SBA, who's also got an ongoing federal investigation because they're the largest shareholder of the patents.
You don't have a copy of it?
I didn't say that, did I?
No, that's what I'm asking.
I said check with my former attorneys, Broskar. They have most of the records.
Check with your former attorneys. They don't represent me. They represent you.
No, no, they did represent me.
Yeah, they're
Yeah,
not going to just
yeah, it's their friend, Call Mr. Armstrong. Ask him if he's got a copy.
with information that pertains to a former client to me.
Did you go through the list of NDAs up in my website?
Yeah, but you told me before and it's not on there. I told you that.
Oh, you know that one might be off site. I'll try to check if it's on microfiche or whatever.
Yeah, I would like to see it.
I'm sure you would. I'm sure you'd like to see a host of video conversations running through my office and the lawyer's office. I'm sure you'd like to see a whole lot of evidence. But you know what? That's it. Look, you're playing the slippery game again. You want to debate me? You want to go into if these are my inventions? That's why these lawyers all jumped around to patent it, huh? Ken Rubenstein, the MPEG guy, is my lead patent attorney. You know, hey, he didn't know what was out there. Come on. Okay, so if you want to play those games, you're wasting your time. If you want to call your client and say, I don't know how you got me tangled up in this, but now I've got some ethical issues I've got to deal with, some insurance issues I should be dealing with my carrier that you should notify them too about, then we're wasting our time here. I'm literally at a loss to really go on debating if Ray Joa outdated me, if blah, 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 blah. You now know what the issues are. You now know who signed the NDAs. If you want to see an NDA, call your client. They got a copy, don't they?
I don't know that they do because I don't
Oh,
know that it exists.
oh,
Do you
oh,
have it
hey,
in your file?
I made it up with the rest of the story. And that should be your whole basis for holding on to your assets for the rest of your life. And I hope you understand that. You know what I mean? Meaning you're gonna risk it all here on those kind of weak arguments that have already been dealt with a long, long, long time ago by far better, smarter people who were involved way, 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 way back then. So, I don't know what you're trying to get. It's either me to tell you that I'm going to file complaints against you, which I've already noticed you in writing, and noticed you in your client's liabilities. If you're failing to do that, you do have issues, and you will be included in all future criminal and civil complaints of I view it regarding the technologies, anything coming forward, and you'll be included into the ongoing RICO.
Must be taken.
No, I didn't say that.
Yes, you did.
No, I never did. See, there you see, you revealed your intent trying to set up a tape call to use against me as like extortion. Dude, I wasn't born yesterday. I know who your friends are. I know who retained you. You are retained by a defendant in my RICO. I take this as a form of harassment. You should stop your tape right here because you haven't gotten me to say anything you think. No, you and Ray Joa could go play with your Adobe Photoshop documents and your tapes and everything else you want and think you're going to get on this call. You're not going to get. What you're going to get is just the fact that if you failed to do what was necessary, sign a conflict of interest disclosure, you're already in all the complaints. The settlement option was for your client to attempt to contact me, which I thought was through you, their attorney, to settle a RICO issue. If you want to do that, great. That's the opportunity I gave you. But the other complaints and the obligations already started when 5 days rolled by. So I won't ask you to reread the documents, and you can say that AT&T had nothing to do with this, and Armstrong didn't know Utley and Wheeler, and that Rubens, all those cool things, and because now you're a part of it. And so now we're married, and you're married to all of those legal issues, and that you should be notifying your partners and your carrier instead of trying to entrap me on a phone call in a legal game, because that ain't gonna work, buddy.
I'm not trying to entrap you in
Oh,
anything.
please, I'm recording this call.
That we have.
I'm recording this call. Okay. Okay, so anything else you want to play, Perry Mason? Okay, look, you got legal obligations, you got probable criminal violations coming at you in a minute. That's all explained in the conflict of interest letter. I thought pretty succinctly.
Well, now you're changing the deal, though. So
I didn't offer any deal. I have not offered any deal.
yes, you did. You said,
You said, will you file further charges? You said, if I could settle this. Well, you haven't settled anything, so I'm filing charges. The charges I've already told you I'm filing as we speak. So I'm in the draft mode.
you said if we could settle, you wouldn't file those, and now
No. You said, would you file any further ones if I could settle? Well, you haven't settled today. So today I can file all the complaints I want. So I'd hurry up and get to your client and settle this. And you know what? It's in their best interest too. So you might as well just tell them. If you stole the guy's stuff, pay him typical and customary royalty, and I'll act as your agent, and hopefully that'll happen before he files on us. Because the SEC,
how do you expect that we're ever going to settle anything if you don't fucking shut up and let me talk?
send money. I just thought, okay, go ahead. Are we getting towards settlement? Because the only talk I'm getting into is that I'm not the inventor. AT&T is not involved. You don't have documents. I mean, really, are we going to go through that? I've already submitted all the documents to federal, international, and then all over the world. Put a bunch of tapes with a lot of people on it, talking about Enron technology transfers, AT&T. Go ahead.
I understood earlier was if I can get AT&T to file anything against my firm, and now you're telling me
No, future.
anyway.
No, if you can get them to settle, I will not file future complaints against AT&T. I will withdraw them from the civil RICO that's ongoing in the federal courts that they should be notifying their shareholders about, et cetera, et cetera. And that's all in the letter. And that's what I said. And I won't file any future ones against you. I've already notified you I'm filing on you. It's in the letter. That's the one you should be sending to your insurance carrier right away.
File anything on me.
It says right in there, after 5 days, you'll be considered to be a RICO participant as well as obstructing justice, et cetera, et cetera, et cetera, et cetera.
Anything as
And I noticed you in the letter about liabilities you would have for yourself and for your clients regarding ethics violations and complaints against you. So I have properly noticed you according to law. So, again, are we going to get into this?
yeah, we need to get into it.
Well, it's easy.
I
It's
wanna
easy.
know.
Here, it's easy. If you're settle with me, all the complaints against your client and your firm will be removed, and I will file no future complaints regarding these matters specifically.
All right. Well, then that's different. A minute ago, you said you're going to do it regardless.
You didn't hear me.
Oh, I heard you.
No, you didn't. And let's get it clear for the tape again.
Oh, it's on the recording, and I know what I heard.
Okay, well here, then you're not listening clearly. If you and your client settle, no future complaints will be made. So the future, hear that? No future complaints will be made. So that means on the day you settle, no future complaints will be made. And on that day, I'm sure part of the settlement will be to remove you from the civil complaints against your client and yourself.
Okay.
Okay? So you've already been complained about. But yes, I would assume that future settlement will bring the end of future criminal and civil complaints against your client, or not criminal, civil complaints against your client, and I believe maybe some of them are attorneys, so ethical if those are involved, would be you would be out of the RICO, and I would notify the court that AT&T settled all uh, issues with said inventor, and I would issue a statement to wherever your complaints are filed that said the same.
And so as of today, though, you haven't added me, my
Oh,
firm.
yes, I did. I notified you. And remember, all I have obligation to do is notify you. So I've given you proper notification that you are in all future cases. I do have to move to amend the complaint and add your name. You can see I do it every few months for the new people who came in and tried to screw me in this game. And all of them, and you can call them all, their names are all there, will tell you they wish they had gone that next step because this isn't going away. You think you're going to cover history and who really Raymond Joa out invented his inventors? You know, all the most fakakta story I've ever heard. So if you want to buy into that, that's where we're at. That's the game. I did give you an offer that all of those complaints against both you and your client, I would be willing to remove you from the civil elements as I can the criminal and any ethical based upon proper settlement. Yeah. There it is on tape for you. So try to misconstrue it however you want. I'm not trying to extort you. I'm trying to, A, see if you're a truly good human being and attorney and trying to do the right thing. If you are, obviously the options to be good are available. I doubt it, and I doubt when I call AT&T next, I'm going to get much more love than I did over at some of the other key participants Intel. But like I said, you call Bruce Sewell. He's over at Apple today, but he fled Intel about 5 minutes later. You know, and so the SEC complaints are real. These are real things. The accounting, the audit, all those people should already be noticed. I'm not. I don't. I don't have to file the complaints. I've noticed the attorney. Now it's your job. Your failure to do that will be a problem for you.
Well, it's important to me to know whether or not you've added into anything if you want to settle anything.
Well, I've added you in by noticing you. So I've added you that as of today, you are added in.
Am I
And
in any of your complaints?
have you signed the NDA with me?
Did I sign an NDA?
Yeah, I sent you over one.
Nope.
Okay, well, sign it. That's a good first step.
Why do I want to sign an NDA?
I mean, not an NDA, a conflict of interest letter, excuse me.
You're not my client. You've never been my client.
Okay, have you run an appropriate conflicts check against me for your client?
I don't need to. They're not representing you.
No, but they're in a lawsuit against me, and I am pro se counsel there. You know what I mean? I don't know how you got sucked into this. I don't know where you fell out of the sky or why so bravely you did. But, you know, you're here. These are real things. And so we're in a pool of conflict. I'm a little worried that you're conflicted because you come in with two defendants, one on each side of you.
What two defendants?
Ray Joe and AT&T are both defendants in my RICO. And by the way, some of your other people, Comcast, etc., in that lawsuit, why haven't they called me yet?
In that case.
What? Who is?
It's an AT&T in that case.
There's only AT&T?
That's the only person I represent in that case.
No, I know. I just wondered how they hadn't come about the other defendants in realizing the Ray Joa I View It story, since it's the first thing you type in about Ray Joa. And then I think there's like 90 pages of the I View It story on everything Ray Joa. So, I mean, they're being sued too. It just seemed a little weird that you're the first brightest guy. But, but then none of that has much to do. So, yes, right now I am formulating ethics complaints against you. I am formulating notice to the SEC, which will be forwarded to all of the federal, state, and international investigators of the IVF matters. And you can just take a look at the SEC letters and the progression and who they went to next for the same progression that's gonna happen here, meaning the SEC complaints and attorney bar complaints were filed, and then those were sent over to the federal and state authorities. Those are in process, and as I said, notice of this is enough for you as an attorney because you have obligation.
All right, and they will not be filed if we can reach an agreement.
If we reach an agreement prior to filing formal, I would have assumed that would be how it would be because we would have settled all this.
All right, well, let's talk turkey. How much money is it that you want?
I don't know, start at 35% of AT&T stock, cash and stock, and then we'll move forward. Okay? So that's my, listen, that's my offer. I wasn't, what, I think I'm kidding?
Yeah, I think.
Really?
Yeah.
Well, you're gonna find one thing out. I don't care. Okay? So go talk to your client, say how much did this technology increase your sales? He's been watching. 35 might be a good idea in stock. Okay? And 8%, I mean, I might have a different view of somebody who wasn't as intricately involved. And maybe the people who are intricately involved can explain that to me, and that price would come down significantly. But if that doesn't want to be explored by your client, 35% would be the starting number. Tell them, I'm coming after 51 in court, okay? And I really believe I deserve it because really, it's, well, you know what, the video, you'd be shut down without video. So you won't have a business model. Your business model will be text messages and phone calls.
Hey, well, hold on. So
But just so you know.
AT&T does a lot more than.
No, listen, I know, but they've been doing a whole lot of video. Okay, we can go talk to your client, tell them that's what I offer, see what they wanna counter offer. Okay, if they wanna show me how much they use my technology, since they know, since they took in the patents long time ago, with their friends, then great, okay? If they wanna negotiate it, and then if they wanna fight it, God bless them. You know, I say that, I hope they do, because if they don't, they're gonna lose a whole lot more than 35%.
Okay.
And based, by the way, that's based on really good lawyers who said that would be a starting point. I mean, and that's from the best counsel who's very intimately involved in this since day one. And remember, go back in this, and there's a lot of attorneys around this. A lot. Well, Ken Rubenstein put his name on it, right? MPEG. How much MPEG transmissions do you do today? Wait, how much MPEG transmissions do you do today? How much TV signal do you broadcast? Do you broadcast any through your lines, any MPEG law video at all? Go talk to AT&T. They seem to have revenue numbers way back when, which was astonishing to me, of the uses of this technology. So, you know, it might be to you a little bit uncomfortable, but don't worry, I did an offer, so that's what I did the offer. Come back with a counter offer that shows me how much they've used my technology, and we'll talk that license fee. Say what?
As I told you numerous times, I have absolute no evidence they've ever used any of your technology.
Okay, great, that's good. That you don't need that right now. You need to notify me, you're really in a retailer. Hey guys, if this unfolds, and it's found that Armstrong had anything to do with these people, a lot of people here could be going to prison, especially for the ongoing failure to report all this to shareholders. I mean, these are serious crimes we're talking about. So that's why the percentage points seem a little bit steeper than regular, you know. What? Does that seem steep? How much did in that Rim Blackberry, how much did the guy get? 50% of the company cash and stock?
No, he did not.
Oh, okay. I don't know.
What the hell are you talking about, man?
What did he get?
He got $550 million.
Oh, okay. Did that total up to half the company?
Oh, I didn't even come close.
Okay, I don't know what the final number was. But I'm sure we'll talk about it. But you know what? Nobody tried to kill him. and all those things, and remember, this ends up in,
He didn't try to kill you either, and they're not tied in any way to the people that did. You have no evidence. You don't even allege that they did.
okay, if you're sure of all those things, then we don't have much to discuss, do we?
No, I guess we don't know yet.
No, we don't. Okay. Thank you.